Hello, everyone. This is Mary DeWeese, an associate in Husch Blackwell's Higher Education Group. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I would like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your question via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. We truly appreciate audience participation and encourage you to submit questions. A PDF of the presentation is available in the resources folder. This program is pending approval for continuing legal education credit to report your hours. Click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow along with a recording of the webcast for watching and sharing. Toward the end of the program, please be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. So that's all for the housekeeping items, and let's get started with our program. Joining me today are Amanda Garcia-Williams and AJ James. Amanda is Husch Blackwell's Chief Diversity, Equity, and Inclusion Officer. Amanda supports the development of an inclusive culture at the firm so that attorneys and staff are best equipped to meet client needs. We are so excited that she's joining us today to share her DE&I expertise. Both AJ and I are attorneys in Husch Blackwell's education law team. We represent colleges, universities, and other institutions of higher education on a variety of matters, including but not limited to employment and in litigation. Today, Amanda, AJ, and I will be discussing the legal considerations related to diversity, hiring initiatives, and affirmative action plans, as well as the best practices for equitable and inclusive recruitment and hiring. I'll turn it over to AJ to begin.
Thanks, Mary. So, as Mary stated, we're going to be talking, the purpose of our program today is to cover what we refer to as diversity hiring initiatives. And at the outset, one important question is, well, what exactly does that mean? And the answer is, it means a lot of different things, and it serves as sort of an umbrella under which a lot of those things fall. Generally speaking, it is a commitment to more equitable and inclusive hiring practices, and also specifically includes written affirmative action hiring plans. Just for clarification, a written affirmative action hiring plan is a term of art used in federal regulations for federal contractors, which is an issue that we're going to discuss in detail here in just a bit. But generally speaking, these diversity hiring programs and initiatives cover lots of different things, and within that first point we have here of a commitment to more equitable and inclusive hiring practices. That commitment can mean a lot of different things, from training on how to advance these initiatives to specific policies and procedures that are in place to ensure that these important initiatives that are gaining more and more focus as a point of emphasis throughout higher education are really being promoted in the proper way. Now, knowing that it is a loaded term and it means a lot of different things to a lot of people, we have a couple questions that we want to cover with you all just to have a little bit more of an understanding for where our audience today falls on this issue in their own mind. So our first polling question that we have here, on a scale of 1 to 5, with 5 being very important and 1 being not important at all, how important is diversity in the workplace to you? We'll give everybody just a little bit of time to respond to that prompt. Give everybody just a few more seconds to get those last answers in. All right. So as we can see here, no surprise, and rightfully so, this is a very important issue to the majority of the people we have on the call today. And I think that's reflective of the stance that higher education's taken, really probably more so than general employment as a whole, but definitely among higher education over the last couple decades, and especially within the last couple of years, given the state of relations in our country and world as a whole. Amanda Garcia-Williams is going to cover kind of unpack some of these results and talk a little bit more about some of the value behind what these programs are, why we should take them importantly here in a second, but we have a few more questions before we get to that point. So our next polling question, are you involved in the hiring processes at your institution? Give everybody a few seconds to get some answers in so we can get an idea on that. All right, a few more seconds and we'll move on. All right. So we have a pretty good mix here. It looks like we've got about 2/3 of our folks on the call are involved in that hiring process, and another third are not. As we'll talk about a little bit later, these programs are not necessarily unique only to people who are directly involved in the hiring process, and the initiatives really are best implemented when promoted institution-wide, regardless of that hiring authority. Our last polling question for everybody, does your university have a diversity hiring initiative? Yes, no, or not sure. Everybody will respond to that. Give everybody a few seconds and we'll move on. All right, let's give everybody just a few more seconds to get the last answers in. Okay. So good news, it looks like we've got a majority of the people on here that are confident their university does have one of these initiatives. Another quarter or so that are not quite sure. No shame in that. We'll definitely cover a little bit of that today, and hopefully the answer will be we do have something similar to that. But with that background in mind and kind of where we're heading and what the makeup of our audience is today, I'm going to turn it over to Amanda Garcia-Williams to talk a little bit about the positives of these programs, why they're beneficial, and why they're valuable in today's environment.
Wonderful, AJ. Thank you so much. And thank you for allowing me to participate today. I just want to set a little bit of framework around why we want to discuss diversity in higher education, why we want to talk about diversity in hiring. And I want you all to reflect a little bit on why we think diversity is such an important and key element to institutions of higher education. That first polling question where so many of you rated 5s and 4s, reflect on why these things are so important. And the framework I want to lay is that we're going to talk a lot about different frameworks and laws and requirements, but I want to put out there that is not the reason why we do diversity. The reasons why we do diversity are so many more things than that, right? Ultimately, from my perspective, we do diversity. We want diverse teams. We want diverse institutions because diversity makes us better. It makes us better at communicating with each other. It makes us more innovative. It makes us more creative. Those diversity of identity, the diversity of perspectives makes our institutions, whether those are institutions of higher education or whether those are law firms or corporations, it creates better teams, it creates better outcomes, and it creates better communities. So we certainly don't just do this because we're told we have to have a program. There are other reasons why diversity in higher education is so key as well. If we really want to build those diverse teams, those diverse communities, this slide here is showing that we still have a ways to go, right? We still have a gap between those that identify as people of color with regard to our undergraduate student population, and then those faculty, those administrators, those university professionals, and how we might benchmark the ways that we're increasing diverse representation with the opportunity for increasing diverse representation. And then the next slide here shows that another reason why diversity is such a key element here in the workplace is that our job seekers want to work in diverse environments. They want to know that their employers care about what they're doing to increase diversity within their organizations. And so those are just a few reasons why this is really so key. Now, we're going to talk about very specifically hiring practices today, and I don't want to lose sight of the fact that we are focused very much on hiring practices and increasing diversity at that first in-the-door onboarding, who comes into our organizations at that first point in time. Of course, I'm a DEI professional, right? So that equity piece, the inclusion piece, how are we creating inclusive environments, equitable practices, more accountability and transparency? Those are really key components to any DEI program. But today we're really focused on hiring. And I'll be back later in the program to talk more about best practices in all aspects of the hiring process. But because we have to do this within a legal framework that can sometimes be complex, there can be a lot of factors, there can be a lot of things to consider, I'm now going to turn it back over to our brilliant legal experts to talk about that framework specifically.
Thanks, Amanda. So we're going to start by talking specifically about affirmative action plans. And as AJ said briefly, affirmative action and affirmative action plans are legal terms of art. We see this language used in federal regulations as well as by the Supreme Court. An affirmative action plan is required for certain institutions that hold certain federal contracts. And these legally required plans carry with them very specific requirements. The first example of a required affirmative action plan comes from Executive Order 11246. Many of you may be familiar with this. This order not only prohibits federal contractors who do over $10,000 in government business from discriminating in employment decisions, but also requires that such contractors take affirmative action to ensure equal opportunity in employment. And a contractor in violation of this order may have its contracts canceled, terminated, suspended, in whole or in part, and the contractor may be debarred, which means the contractor would be declared ineligible for future government contracts. So compliance with this order is pretty significant. This order was first issued in 1965. It's been subject to many amendments, including in 2014 when President Obama expanded it to prohibit discrimination on the basis of sexual orientation or gender identity. So the current language of the order is up on the slide in front of you. And it's important to note that this is enforced by the Office of Federal Contract Compliance Programs, or OFCCP. As relevant to our presentation today, this EO requires federal contractors with 51 or more employees and contracts of $50,000 or more to implement a written affirmative action plan to increase the participation of minorities and women in the workplace. If a workforce analysis demonstrates their underrepresentation, meaning if there are fewer minorities and women than in the contractor's workplace than would be expected given the demographics of the labor pool of those qualified to hold the positions available. The written affirmative action plan is a set of specific and result-oriented procedures to which a contractor commits itself to. A good faith effort to comply is required. It's developed by the institution, it's kept on file and carried out by the institution, and OFCCP may request it for purposes of conducting a compliance review. So if you're one of these federal contractors, which many institutions might be, that's required to have this written AAP, your AAP must identify which, if any, areas of your workforce reflect an underutilization and set goals by which you will reduce or overcome that underutilization. You might, for example, set goals related to outreach, recruitment, and training as an effort to increase the diversity of your candidate pool. The order makes clear, however, that the selection decision for the actual hiring decision is to be done on a non-discriminatory basis. So the executive order is not the only affirmative action-based requirement that OFCCP oversees. There's also the Vietnam-era Veterans Readjustment Assistance Act, or VEVRAA, which prohibits contractors from discriminating employment against protected veterans and requires certain contractors to take affirmative action to recruit, hire, promote, and retain veterans. This law applies to federal contractors and covered subcontractors with a contract of $150,000 or more. And I just saw a great question coming through the chat, which is what determines if you're a federal contractor? Can be Title IV funds. There is guidance from OFCCP, making clear that Pell Grants, for example, don't qualify an institution as a federal contractor required to make these plans. Rather, it's if you have like a supply or service contract with the federal government in any capacity. So it really is fact specific as to whether you hold a federal contract or not. If you're required to comply with the affirmative action portion of this law, you have to establish annual hiring benchmarks for protected veterans. These are either established by using the OFCCP benchmark, which is updated annually, and that takes the national percentage of veterans in the civilian labor force and sets it as the benchmark for veterans in your institution's workforce, or you can use this other method called the 5-factor method, which we won't go into today because it's a much more in-depth analysis. Finally, the Rehabilitation Act also requires that federal contractors take affirmative action to employ and advance in employment qualified individuals with disabilities. So more specifically, Section 503 of the Rehab Act prohibits federal contractors and subcontractors from discriminating in employment against individuals with disabilities and requires those employers to, again, take affirmative action to recruit, hire, promote, and retain these individuals. This applies to contractors with government contracts in excess of $15,000. Those contractors who have 50 or more employees and a contract of $50,000 or more are required to have a written affirmative action plan. These regulations include what's called an aspirational utilization goal of 7%. OFCCP guidance says that they intend that this 7% goal serve as a yardstick against which contractors can measure the success of their efforts in outreach to and recruitment of individuals with disabilities. And together, these three laws, Executive Order 11246, the VEVRAA, and Section 503 of the Rehab Act, govern required affirmative action plans. However, institutions may wish to go above and beyond these requirements, and in doing so, it's important that the complex legal framework governing race, ethnicity, and gender-based decision-making in employment is considered. I'm seeing some more questions come in the chat about that, and we're going to actually turn to that next. So I will turn it over to AJ now to begin that discussion.
Thanks, Mary. Yeah, so as Mary talked about, there's a range of things that certain entities are required to do in terms of having these plans on file. And as Mary stated, a lot of times we have institutions, as a result of many of the benefits that Amanda outlined earlier, that want to go above and beyond what those sort of minimum requirements are. When that happens, occasionally, those plans, those initiatives, policies, and practices are subject to some legal challenges. And really what we're talking about, those legal challenges are basically folks opposing the affirmative action hiring plan, the diversity hiring initiatives, whatever the issue might be that folks want to bring a challenge to, normally in the form of a lawsuit. So to start off, we're going to go over a couple of the most common suspects here, basically the laws that we frequently see in these legal challenges that form the basis of those challenges. The first is the Equal Protection Clause from the 14th Amendment of our Constitution. Technically, the Equal Protection Clause is only going to apply to public entities. However, as we'll discuss here in a moment, a lot of those same requirements become imposed on just about everybody in higher education by virtue of Title VI and the fact that most of our entities receive federal financial assistance. Under the Equal Protection Clause, a wide range of protected classifications are covered. These protected classes include things such as race, sex, and national origin. One important nuance to note here is that when there is a constitutional challenge pursuant to the Equal Protection Clause, the protected category at issue is in many situations going to be determinative of what standard of judicial review it receives. So generally speaking, in law school, we have strict scrutiny, rational basis, and intermediate scrutiny. We'll cover that in a little bit more in detail. But depending on what the actual protected classification at issue is, has a lot to do with which one of those standards is going to apply. As I talked about briefly before, we also have Title VI, which prohibits discrimination on the basis of race, color, or national origin, and that's applicable to entities that receive federal financial assistance. Again, higher education, that's going to cover a lot of us, if not all of us. Moving on, the next big area that we see challenges from is Title VII. Title VII is going to apply very broadly to both public and private entities with over 15 employees. If you're catching on to a theme here, that's, again, almost all of higher education. So when we look at Title VII has a very wide scope of types of discrimination that it bans, both in terms of the protected classifications and the actual conduct that's subject to those restrictions. Title VII broadly prohibits discrimination on the basis of race, color, religion, sex, sexual orientation, gender identity, and national origin. And again, the method in which that discrimination comes, in which Title VII prohibits, is really what differentiates it from a lot of other statutory schemes. Namely, Title VII prevents and applies to both intentional discriminatory acts, but also unintentional acts that end up having a disparate impact on one protected classification of persons. We frequently see these Title VII claims pop up in private litigation from individual employees seeking monetary damages. And a lot of times we see these Title VII claims packaged in with constitutional claims, Title VI claims, and Title IX claims as well. Title VII tends to be a pretty frequent player in this arena. The next policy we should all hopefully be familiar with in higher education is Title IX, which of course prohibits discrimination on the basis of sex in educational programs receiving federal financial assistance. Typically speaking, the very, very broad non-higher education environment here's Title VII and thinks athletics and equal participation in athletic programs among gender. Well, Title IX, as all of us know, applies to a much, much broader range of those issues, including employment actions, and again, focusing on the element of sex in those actions. Moving on, the last couple relevant laws we have to cover here are the Americans with Disabilities Act and Section 504 of the Rehabilitation Act, both of which protect individuals with disabilities. The Americans with Disabilities Act applies to public entities and private employers alike with more than 15 employees, again, almost all of us. And Section 504 of the Rehabilitation Act applies to programs receiving federal financial assistance, again, almost all of us. Both these statutory schemes not only provide protections to persons with disabilities, but also prohibit discriminatory practices against persons either employed or prospective employees who are disabled. The last category that we want to mention just at the outset, and we're not going to go into much detail here on this because frankly our audience is from all across the country, and these state constitutions and state level statutory schemes vary widely from place to place. But it's important to note that many state constitutions are modeled after our after the United States Constitution, and specifically the Equal Protection Clause, to include similar protections and also form a basis for legal challenges under those state-level constitutions. Again, there's also state statutory equivalents to many of the statutes that we just, statutory schemes we just discussed, particularly Title VII, that also in a lot of situations are going to be applicable to the same type of efforts to challenge our diversity hiring initiatives. One important thing to note for the state constitutions and statutory schemes is the supremacy clause, which basically requires that federal law on the same issue is going to preempt and kind of take supremacy over those state level laws where there's a conflict. Also important to note that state law can be broader and in some cases more restrictive than federal law, but what state law cannot do is permit something that federal law expressly prohibits. State law can also not, kind of reverse token of that, state law can also not prohibit something that federal law expressly requires or permits. So just keep in mind that depending on where you're at in your individual state, there may be unique considerations for everybody to consider based on your state constitution and those statutory schemes. So with that background in mind of those relevant laws, we're now going to start looking at how different types of diversity initiatives are reviewed when they are challenged under some of those provisions. I'm going to start by looking at diversity hiring initiatives that are aimed at promoting racial and ethnic diversity, and then I'm going to turn it over to Mary here in just a little bit to cover some other types of initiatives. Please keep in mind that this is not meant to be an exhaustive list by any means of the potential legal challenges that these kinds of policies can face. It's really, what we're looking at here is going to be the sort of usual suspects that we see these challenges brought under. And those usual suspects for racially focused initiatives are constitutional challenges, usually under the Equal Protection Clause, challenges under Title VI, and those under Title VII. In a lot of situations, we might see all three of these in the same legal action. To a certain extent, they can be very duplicative of one another. But there are some unique differences among, especially between Title VI and constitutional challenges compared to Title VII. For the purposes of employers, challenges seeking monetary damages for individual persons tend to be more commonly asserted as Title VII actions, although certainly we do see those same kinds of actions brought for the other provisions as well. By the same token, challenges seeking to prohibit a policy or practice in general are commonly challenged under these constitutional challenges and Title VI. Moving right along, we're first going to look at challenges under the Constitution, Equal Protection, and Title VI. Typically speaking, the way Title VI works is it imposes those same constitutional restraints and procedures to review the policies that a normal constitutional challenge would be. If you recall back to our discussion earlier about the relevant laws, one thing that differentiates Title VI is that it permits, it basically applies equal protection to private entities as well as public entities. Again, the prerequisite to that being the receipt of federal financial assistance. So when we're looking at race or ethnicity-based plans, those plans are subject to strict scrutiny. If you went to law school, you probably remember hearing about different levels of scrutiny in your first-year con law class. That might be giving everybody a little bit of a nightmare flashback. But as a refresher, there are generally, and I mean very, very generally, three levels of scrutiny, those being strict scrutiny, intermediate scrutiny, and rational basis. Strict scrutiny, as the name suggests, is the strictest standard, meaning it's the most difficult to satisfy. Again, difficult to satisfy, not impossible to satisfy in many situations. At any rate, the test that we apply for strict scrutiny is a two-step analysis, with step one requiring that there be a compelling interest that exists in order to warrant whatever the challenged policy or practice is. The second step of that, if you satisfy the compelling interest, is to look at whether or not the challenge policy or practice is being applied in a narrowly tailored fashion to address the compelling interest that's been identified. And that, as you can imagine, requires unpacking those two steps quite a bit. Just as a little bit of background, we've seen these challenges on race or ethnicity-based initiatives in enrollment and student admissions with some regularity, and other areas that apply to higher education other than general hiring as a whole. In terms of what counts as a compelling interest applicable to hiring, which is what we're going to discuss here in just a moment, one compelling interest that's been recognized is remedying discrimination where there's been a judicial finding of discrimination. Again, the differentiating factor there is that there's been a judicial finding. Other compelling interests in higher ed that have been recognized but are not necessarily applicable to general hiring include that same compelling interest that we normally see in student admissions, which is an interest in diversity of the student population, which has been found in advance, rightfully so, to promote the value of the education and the experience that an institution is able to offer. Two other areas that are somewhat similar to one another include law enforcement and the need for diversity among a police force in terms to meet their operational goals. These same notions have been applied in some instances to campus police departments, which face many of the same operational difficulties and dilemmas that general large metropolitan police forces deal with on a daily basis. But it is important to note that those are compelling interests that have been recognized previously. So with respect to the first prong of the strict scrutiny test, which is the compelling interest, one big area that's been recognized as a compelling interest to satisfy the test is remedying a manifest imbalance for the employer's own patterns and their existing workforce. So what does that mean? It means that an employer may have a compelling interest in addressing clear imbalances between racial or ethnic minorities at that employer's own workforce and specifically within the different categories or positions they have, and that same racial minority representation in the overall pool of qualified candidates or the industry as a large. Important to note that in able to act on this compelling interest, you must be able to demonstrate that the disparity exists. And if challenged, showing that disparity is going to be the key area of contention for this prong of the strict scrutiny test. Typically, demonstrating this disparity requires some sort of statistical analysis done at the job category or discipline level. In higher education, we might think of those general job categories or disciplines as, tenured professors, for example, or head athletic coaches. In order to demonstrate that disparity, one possible way that has been done and has been recognized is to use a standard deviation analysis, basically showing that there's a difference in the qualified applicant pool among a certain racial classification and the institution's own workforce that exceeds 2 standard deviations. So for all of us, myself included, who are not statistics experts, what that means is that you would have to have a statistical analysis showing that the representation of a certain racial or ethnic minority among your institution's current workforce or in a particular discipline is more than 2 standard deviations lower than what that same minority representation is in that industry as a whole or in the qualified applicant pool. Basically, if there can be a showing that disparity exists, then it opens the door for actions to be taken that can help close that gap and erase that disparity. Obviously, as anybody familiar with stats knows, that a statistical analysis largely depends on your population. Many times, depending on how particular we're drawing the scope here, a job or discipline is not going to have a very large sample size, at which point it is possible to show that a racial minority's general percentage representation at an institution within a particular field is greatly disproportionate to that same racial category's percentage in the broader industry. It's much less certain and requires a little bit more of a much more obvious disparity, if you will, than a full statistical analysis would, but it is an option. At the end of the day, the big takeaway for this is that the stronger the supporting evidence, that being statistically proven data, the better odds that a challenge, practice, or policy is going to have of passing strict scrutiny. I'm seeing one question come in about the confidence level for that statistical analysis. There's really not a ton out there that talks about the statistical parameters of it. It's really analyzing what, in particular cases, what's been provided. It is acceptable, though, for those small populations to use a Fisher's exact analysis. So one other piece that we have on here that we need to talk about is what doesn't count as a compelling interest. So, and when I say what doesn't count as a compelling interest, what I mean by that is things that the courts have previously found not to constitute a legally sufficient compelling interest for the purposes of strict scrutiny. These types of things are, certainly valuable policy points, but from a pure legal standpoint, courts have ruled that they are not sufficient to pass the strict scrutiny test. And really, when we look at that, there's two big considerations that have been found to not amount to that compelling interest, one of which is social justice to remedy past discrimination in the broader societal context, i.e. systematic racism, or policies that set quotes or caps that match the percentage of employees from a particular race within the broader society. Important to note, there's not very much authority on this, and a lot of the cases here date back to before 2000. A lot of when it comes to these diversity hiring initiatives, gets pulled from student admissions processes, and really hasn't had a ton of authority given on it last year, which makes it ripe for rulings in the near future, given the renewed focus on the subject. The next part of the strict scrutiny analysis is narrowly tailored, which requires that the policy or practice be implemented in the most narrow fashion to achieve that purpose. There's a lot of nuance that goes into the narrowly tailored analysis, but generally speaking, plans or initiatives that consider race as the determinative factor or a condition to a hiring decision are usually viewed as unconstitutional. If race is considered just one factor among others, it's a less rigorous path, but still one that is somewhat difficult, and it requires the institution to show that there's not a race-neutral way to increase diversity, or that there's not a strategy that would accomplish that goal with a less emphasis or weight placed on race. Again, we really break these down into two different categories that are analyzed by the courts, and those are race-conscious plans and racially exclusive plans. Racially exclusive plans are going to face the harshest challenges, and it's to date somewhat unclear if those policies or practices are ever capable of passing strict scrutiny. Racially conscious plans, on the other hand, are those that consider race as a factor, but not a prerequisite or a determinative element. Those are somewhat preferred under this analysis and are capable, with documented records, of passing the strict scrutiny test. Moving on to Title VII claims, that's the second big category of challenges to racial or ethnically based diversity initiatives. A lot of these elements overlap somewhat with our constitutional challenges, but there are some key differences. Again, Title VII is going to prohibit intentional and unintentional discrimination, which includes strategies that create a disparate impact against one racial category or ethnic category. Individual challenges under this are subject to a burden-shifting analysis, which requires a challenger to show a prima facie case of discrimination, which is a relatively low bar, basically requiring them to show that they're a member of a protected class, they were qualified for a position, and that subsequently they were not selected for a position and that it was given to either a member of a different racial category or was left open for further people to apply for despite that person being qualified. If that initial burden is met, it shifts to the employer to show a legitimate non-discriminatory reason for the decision, such as a lack of qualifications, a discrepancy in terms of logistics, arrangements, pay, what have you, something that's legitimate and, again, non-discriminatory. If that prong of the test is met, then the burden is going to shift back to the challenger one more time to basically show that whatever reason the employer is given is not, in fact, the true motivation and is pretextual for discriminatory motives. Typically, these challenges to racially conscious diversity initiatives are going to be based on disparate impact. And to prevail in a disparate impact, what a challenger has to do is show that a given practice or policy is, in fact, creating a negative impact on a particular racial or ethnic classification, even if it's unintentional, and that the employer basically cannot show that whatever the practice or policy is job-related or aligns with a necessity. Or the challenger can demonstrate that this impact has been created and there are less impactful strategies that would not have that same negative impact that the employers failed to adopt. One other important kind of consideration in all of this, especially with that first prong, is a business necessity. So if a particular qualification, job duty, or prerequisite to applying for a position concerns things like a record of inclusivity or demonstrable commitment to equity, either prior training or experience, that's something that has been accepted as business necessity for many positions, and that's also racially neutral on space. So a couple of different strategies that do not directly affect those employment decisions are often viewed more favorably under Title VII challenges. Two big examples of those being inclusive outreach to prospective candidates, which means how you market and promote a job so as to maximize the interest and applications from a diverse pool of candidates. And then again, the same issues we just talked about, which is requiring candidates to have a record of inclusion or training and experience to promote diversity efforts. Those things are racially neutral, but generally result in a higher percentage or higher inclusivity of a diverse applicant population. Another important consideration here is that when plans do specifically consider race for the purposes of Title VII, it's going to be very, very similar to the analysis done under a constitutional challenge. So it's going to have to be related specifically to that employer, to their historic record, to their representation, their current workforce compared to that qualified applicant pool or industry as a whole, and is also going to need to be supported by data and documentation similar to that required to pass strict scrutiny. Again, this is meant to be a very broad overview of this topic, but that's a kind of our discussion on these challenges that we see frequently with respect to racially or ethnically based initiatives, just to give everybody a flavor for what those look like, what the courts look at and analyze, and kind of where some of the direction has taken us in the past and where it's going in the future. And again, these are based on, in many cases, somewhat dated case law that's right to be brought up again and reviewed by courts, given the emphasis placed on diversity initiatives over the last couple of years and the increased role it's playing in our society today. So with that, I will turn it back over to Mary to talk to you guys a little bit about gender-based initiatives.
Thanks, AJ. And I'm going to go through this section a little bit quickly, because we just have a lot to cover. But before I jump in, I wanted to answer a question that came in the chat that raised, the requirements that AJ was just talking about, those constitutional requirements, seem much stricter than what the executive order requires. And I think that goes back to what AJ said about, race-conscious plans versus decisions that, like what I would call like race preferential plans, let's say. So a race conscious plan that might, have initiatives related to recruiting, for example, might not even trigger constitutional review. However, a race preferential plan where firing or promotion decisions are, where those decisions specifically consider race, are going to trigger that strict scrutiny. When it comes to gender-based initiatives now, these are generally subject to what's known as intermediate scrutiny, although there is a little bit of a circuit split around that. Some circuits have held that affirmative action programs that deal with gender are actually subject to strict scrutiny. But as a general matter, if you have a plan that's challenged, it'll have to satisfy intermediate scrutiny, meaning it must substantially relate to the achievement of an important government objective. And those important government objectives can be a manifest imbalance that reflects the underrepresentation of women in traditionally segregated job categories, an interest in avoiding employment decisions that have a disparate impact on women, and then all of the compelling interests that AJ mentioned. Any plan that considers gender when making hiring decisions must be based on a sufficient evidentiary foundation, which could be actual evidence of prior discrimination by the employer. And I did see a question come in about, are we opening ourselves up to liability by looking at our prior actions? That's going to be really fact-specific around the statute of limitations and whatnot, but that's definitely something to keep in mind. But unlike race, which is subject to strict scrutiny, on the intermediate scrutiny standard, which is lower, societal evidence of an imbalance in the job category compared to the job market overall might be sufficient. And there are cases that have, the Supreme Court has upheld a gender-based affirmative action plan under Title VII. Sex was one of numerous factors considered in that plan, and the intention was to balance the workforce, not maintain one, meaning there was evidence that the workforce was that there was possible discrimination in the workforce. Now, employers might also want to consider things like disability in their hiring decisions. Through a lot of Supreme Court precedent, race, ethnicity, national origin, and religion have been identified as suspect classes, which require strict scrutiny review. Sex and gender have been identified as quasi-suspect classes, triggering intermediate scrutiny, and then distinctions based on other categories or classifications simply must satisfy rational basis review, which is a fairly easy standard to satisfy. There must just be a rational relation to a legitimate government interest. And an important thing to note is that in considering disability in hiring, neither the ADA nor the Rehab Act nor the Constitution prohibit affirmative consideration of disability, meaning the EEO, the quotes on your slide that the EEO has said, the EEOC has said that an employer is allowed to hire someone because he has a disability, and a rejected applicant cannot sue for discrimination based on the fact that he does not have a disability. So those, what we call, like reverse discrimination suits, where maybe white men might sue a university when they're not hired, and there's some diversity hiring initiative that's seeking to hire more women or people of color. Those sorts of suits don't really arise in the disability context. So real quickly, what does this all mean? We just gave you a lot of legal jargon, and how does it apply to hiring at your institution? So if you're going to have a plan to hire more women or more people of color, and a plan that specifically sets goals around hiring, as opposed to, say, goals around increasing the diversity of your candidate pool, you're going to possibly trigger constitutional scrutiny, and you need to have the data to back it up. So look at your statistical disparities. Compared to the relevant labor pool, is there an underutilization of women or of people of color at your institution and in that job category? Now, the relevant labor pool might be the pool of candidates in your geographic area, but when it comes to things like faculty, let's say, we know that faculty kind of come from all over, so it could be a national labor pool, and there's possibly some wiggle room in that data analysis to figure out what the proper labor pool to look at when you're comparing those demographics. And then your plan should set identifiable goals. You know, it needs to be tailored to your interest in diversity and more specifically in your interest in remedying these imbalances. So generally speaking, like we said, it should be supported by data. You shouldn't use strict quotas, and you should allow for flexibility and revision. And if you have a federal contract, your written affirmative action plan must comply with those OFCCP requirements. The one other thing I want to note before we turn it over to Amanda to discuss in more detail best practices for hiring generally is that you know, we've talked a lot in this kind of legal compliance section on an interest in remedying a statistical imbalance. Now, in the student admissions context, which arguably could change when the Supreme Court considers affirmative action in admissions next term, we've seen courts favorably consider the work an institution does on the front end to study the need for diversity. So in addition to the actual data analysis, if you're interested in you know, coming up with a diversity hiring initiative, it might be useful to have focus groups at your university that are talking about the importance of having a more diverse workforce. But again, we have not seen courts recognize something like diversity in the workplace, period, as a compelling interest for purposes of the Constitution. So you'll still need to back up that interest with your interest in remedying that statistical imbalance, which should be supported by the data. And that can sometimes be hard to do. So, you know, like AJ said, it's an open question whether race or gender preferential programs can withstand constitutional scrutiny in this day and age, but that doesn't mean that there's nothing you can do. There are a lot of other practices in the hiring context, and so that includes, you know, everything from recruitment to hiring to retention that you can put in place to increase the diversity at your institution. And I'm going to turn it over to Amanda now to go ahead and discuss some of those.
Wonderful. Thank you so much. Okay, so generally, as an overview, one of the things we're going to talk about is how you can consider every part of the hiring process and really take a close look from a DEI standpoint on how you can improve some of those processes. Understand how implicit bias may be impacting those decisions, put in some bias interrupters into those processes, and then really use data and to consider who is accountable for some of those processes. So we've been talking a lot so far about different plans, but also different decisions that are made right at the hiring decision point. So who are we actually offering this job to? I'm really going to ask you all to think about every stage of the hiring process and where you may be able to make improvements or consider best practices. So for example, really starting with that job description. What does the job description say? What are the minimum requirements in that job description? Are they accurate? When you're saying something is required versus something is preferred, when you're talking about minimum years of experience, for example, really push yourselves and push those involved in the hiring process to be really thoughtful and consider whether those are in fact requirements, whether they're preferred, and whether there's any room there, because you really have to consider who you're excluding with regard to those minimum requirements and who you may be bringing into the process. When you think about posting the job, of course, I'm sure you're all familiar with thinking about where we're posting. Are we just posting on our own website? Are we utilizing third parties? Are we looking at job boards? How long should those postings be up? Are we only posting for 7 days? Are we pulling something down? When we're thinking about advertising positions, so not just cutting and pasting a job description, but really advertising what this job entails. The employee value proposition of taking this job, and thinking about how you're presenting your institutions to different groups of people in those job postings and advertisements. Be very thoughtful about which assessments you're using and why you're using them, and make sure that they are relevant for the role and that they're relevant for the skills that you actually need for those roles. Assessments, even validated assessments, can oftentimes benefit or exclude certain populations, and so being really thoughtful about that assessment phase is important. When you think about who's screening those applications, where are they coming in? Are there analytics tools that are automatically screening based on minimum qualifications? Are there actual people doing an initial review of applications? And what types of criteria are they using to decide whether to send applicants on to the next level within the process? Really think about your interviews. Who is on the panel? Do you have diverse identities, diverse perspectives among the people that are interviewing? Are you doing some kind of consistent questioning or consistent assessment on who's getting those highest marks, and how we're evaluating the candidates and their answers within the interview, and what those questions really are. So for example, we talked earlier about the fact that you can build into your job descriptions for certain roles an expectation that this individual exemplify inclusive leadership qualities, for example, or demonstrated commitments to equity. Well, if you're putting that in your job description and you're asking a question to your candidates about how they've demonstrated that commitment to DEI, do you have a consistent understanding for what a good answer to that might even be? Does the rest of the interview panel understand what that might be? And then really looking at who is getting an offer and who's actually accepting that offer. Sometimes we see that candidates from different minority groups, racial minority groups, gender groups, are actually getting offers at higher rates, and they're accepting those offers. And that might be a signal that their experience was not great throughout the interview process, or they're not convinced that it will actually be a workplace that values them and that considers them as kind of a whole person. You also want to think about implicit bias and how it might be impacting. This is just a quick list of all different kinds of bias, and of course we could spend a whole hour or days on implicit bias training. But at every level of that process that I just went over, at every stage of hiring, implicit bias can be a factor, and so you really want to scrutinize whether or not that might be happening. And keep in mind that even if you're doing implicit bias training, while that training is critical, training alone will not improve these outcomes. You have to actually implement actual implicit bias barriers, right? I like this little picture because it shows that sometimes the way that our minds work, even if you tell someone on the picture on the right to push on that handle, they're going to pull because it's a pull handle. So you have to actually create systems that work with the ways that our mind works. And you have to think about how you're holding people accountable for these processes. Use data and accountability at every stage of the process. You need to be thinking about where people are falling out of your candidate pool. You should be collecting and analyzing that data to try to see if there's a different way or a different opportunity that you could go about it. It may be that the data will show you there could be some implicit bias happening within the process, or it may be that it's showing you that there is an assessment that is disproportionately affecting minority candidates. But if you're not monitoring the data at each stage of that process, you're not really getting the overall picture of your diverse hiring processes. Okay, we're right at the hour, so I'm going to turn it back over to you, Mary.
Thanks, Amanda. And we have tons of questions that came in, and we'll review those and follow up with people as appropriate. I do know that some of the questions asked early on were eventually answered later in the program. We want to thank you so much for joining us for our program today. We hope the information provided was helpful for you and your institution. If you have not already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback really helps us in providing quality future programs. And as a reminder, the program is pending approval for continuing legal education credit. Please download the certificate of attendance from the certificate widget at the bottom of your screen. Finally, a recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you. And this concludes our webinar. Thank you so much for joining us today.